If you're having a dispute with your ex, most people will tell you that going to family court should be a last resort, except in very limited circumstances. But if you don't go to court, what are your options? On today's episode of Family Matters, alternatives to family court. Everyone knows that family court litigation is time-consuming, expensive, complicated, highly stressful, and often unpredictable. What are the alternatives to family court? How much do they cost? How long do they take? And are they effective? That's what we'll be discussing today. Let's meet our first guest, James Lowen, who is the CEO and president of Smartsettle Family Resolutions. James, thanks for being on the show.
Thanks for having me.
Now, you work with a process that negotiates separation agreements, correct?
That's correct.
And you use something that you called eNegotiation.
That's correct.
What is that?
Well, broadly speaking, it's a software-assisted negotiation process that helps the modern family deal with the complex issues that need to be put into family agreements. More specifically, it allows lawyers and mediators to deal with any number of issues and allows them to reduce the emotional impact through the use of the software and allows them to resolve issues in an optimized way so you actually get a better value for their negotiation because they've used the software.
How does software reduce emotional impact?
Well, when you take the many issues that confront a couple when they're separating, financial issues, non-financial issues, parenting time,
right. And your background is as you're a mediator.
That's correct.
So how does the software reduce this emotional tension?
Well, it allows us to move the direction of husband as problem or spouse as problem and move it into a discussion of the issues on a computer screen. So we can represent all of the negotiating issues on the screen in one place where we can put in what they prefer, what they think about, how important the different issues are. We get all of that onto a screen where they can easily review it. And because we negotiate all of the issues at once, we can actually help them think about the conflict as a whole story and negotiate their separation agreement as a complete package.
So do the people not negotiate face-to-face?
They can. Our process, our software allows us to do face-to-face work when that's helpful, and it allows us to do it separately when that's helpful. Some cases, the couples do not want to be in the same room, even in the same building, and especially when we get issues of family violence going on, we want to ensure safety and convey the fact that they are in control of the process.
How are they in control? I mean, who's running this? Are there lawyers there that are working with each party? We
don't bring lawyers in directly in our Smartsettle Family Resolutions, but we are hoping that lawyers and mediators will make use of our technology. So it can be used by lawyers and mediators to integrate into their own practice. But it doesn't have to have a lawyer present. Essentially, a person who's been trained, certified in the software and has the mediation training as well can help a couple work through the process.
And is it, I guess, very useful then for people who are at a distance to be able to negotiate? I mean, I'm just thinking out loud here. Right. This is very useful if you've got two parties who have separated and they've each gone their separate ways and they're at opposite ends of the province or state or country. Yep. You can use this software, but you must have to have somebody there that's giving you advice on what to offer, what your rights are, what your obligations are. Right. How does that work?
Absolutely. We want our participants and the people who are working through an agreement to understand what they're agreeing to understand the impacts of various decisions that they might be making. And so we do recommend and encourage independent legal advice, financial, professional advice, sometimes counseling. Sometimes we advocate that they go back and talk with their family or whoever it really they need to help them clarify what decisions they're making and what's going to be good for them moving forward.
Are there privacy issues that are involved because you're dealing with a technology-based system?
Well, in any technology, there is that concern, you know, with privacy, and the software that we use integrates well into the security systems that already exist in the computers, and our servers that we use are bank rate encryption, and so we pay attention to the ongoing developments in that area.
Is there an ideal kind of client that's best suited for this kind of process as opposed to the traditional mediation or litigation?
Mm-hmm.
Because, you know, one size doesn't fit all in family law.
No.
Really, it's so case specific based on the particular dynamics of the couple. Mm-hmm. So who's the ideal client for this?
Somebody who has a lot of issues to deal with in terms of...
That's pretty much everybody.
Exactly. So when it comes to any case that there's more than one issue to be negotiated, they need a formal agreement at the end of it, and they want to make sure that they get the best agreement possible. So we really set ourselves apart in having a technology that allows us to optimize. So the value of the agreement will be 10 to 20% greater using our software than if they do a traditional negotiation without.
Why? What does the software do that adds quality to the agreement, the final product?
Well,
does it make you focus in a different way than face-to-face negotiations would?
It does. It really allows you to think and assess the impact of various agreements. Most processes will, you'll get a proposal and it'll be 8, 10, 12 pages long, and you've got to go through it and figure out what this proposal is about. With our software, you can look at 2, 3, 4, 5 different proposals within a 1 hour period and assess their value very quickly and think about, how do I feel about these? How does this proposal change how I feel about these other issues? And so we're able to not only talk about issue by issue, we talk about, well, how does a change in this issue affect this other issue? And so we can link things together and create a much better outcome.
I think you're teaching people how to think. And I really appreciate it. I think everybody needs to focus better, especially when you're dealing with such an emotional issue. Thank you, James, for being on the show.
Thanks for having me.
After the break, we'll meet lawyer Michael Butterfield. Stay with us. Welcome back to our discussion of alternatives to family court. I'm pleased to welcome our next guest, Michael Butterfield. Welcome, Michael, to the show.
It's very good to be here.
You are a lawyer and a mediator.
Yes, I'm a lawyer and I've practiced for about 12 years as a family litigator. And over the last 4 years, I've practiced a great deal of family law mediation, and I'm just starting arbitration.
Can you explain to us what mediation is?
The traditional view of a lawyer's role in a family dispute is to go to court, argue things out for their clients, and eventually get a decision from a third-party decision maker like yourself.
Right.
Reality is that that's very expensive, very time-consuming, and there's no confidentiality to it. What mediation does is it gives the individuals who are involved, the parties, the ability to structure an agreement that best suits the needs of them and their families. It's quicker, it's confidential, and in most cases, it's more cost-effective.
I think mediation is so popular because it puts the dispute resolution in the hands of the couple themselves, and with the help of an expert mediator, they negotiate and try to reach a compromise.
Yeah, now some people get the impression it's like a car sales deal where each party goes in and says what they want and this is why they want it. The reality, though, is mediation is more than that. It's getting to the underlying interests that the parties have to try and find the common ground. The reality is when we're dealing with children, the common ground is the children, and that's some of the most rewarding sort of mediation, because you can get people who come into a mediation who have one set of demands, and they'll come out of it with a compromise.
Who are the best candidates for mediation?
Really, anybody who's willing to try and work on a solution is a good candidate for mediation.
You mean, what if there's been domestic violence, one party is afraid of the other, there's some kind of power imbalance going on between them? How could we expect them to sit down and negotiate with each other on a level playing field?
Well, there's never is a level playing field. There always are power imbalances. Domestic violence, power and control, threats, they're all important issues. They're not served, those issues aren't addressed any better by the courts than through mediation. When I first started mediating, I was of the view that if there was domestic violence, you should never mediate. I've moved away from that view now because I've found that domestic violence situations quite often can be addressed through mediation where they're not addressed through the court, because the court can only issue protection orders, prevent the parties from being together. When there's children involved, the parties have to get together at some point. So what mediation...
Well, doesn't it depend if they can feel safe?
And I think that's part of what you do with the mediation in that sort of situation, is you figure out what the underlying cause of the power and control issues are, address those underlying causes, and put into place a safety plan.
Well, how does mediation address an underlying cause if there's been abuse?
I think we've got to look at the spectrum of abuse. There's abuse which can be very mild, which can be just simple power and control, to the point of extreme physical violence. Extreme physical violence, individuals who've perpetrated those sorts of offences have engaged in criminal activity, and they are not going to be suitable for mediation.
No.
However, at the other end of the spectrum and to the middle of the spectrum, situational violence, such as violence that only occurred during the separation period.
Something that's out of character for one of the parties, or perhaps very spontaneous and not at all a pattern.
And one of the nice things about mediation is the party that is afraid can be empowered by mediation because they're given the opportunity to take control of their lives and their situation.
So the mediator sits down with both parties together and tries to help them express what it is they want and reach a compromise?
In essence, yes. The process is that we would meet with each party individually first. At that point in time, we do a domestic violence and power imbalance screening process. It takes about an hour and a half. We figure out, are there any safety concerns, what can be put in place to address safety concerns. This can include protection orders. We've certainly been in a situation where we've suspended mediation, obtained protection orders so that the parties can only meet through either the courts or through mediation, because that sets the necessary safety framework in place. We then go into the mediation, and the first mediation is generally a sort of getting to know the parties. And this is, to my mind, where it's very important for a skilled mediator to be able to understand where both parties are coming from and also treat both parties fairly.
Is this cheaper than litigating?
Invariably, if it's successful, it's cheaper. If it's unsuccessful, then it's just an added layer.
But you mentioned at the beginning arbitration.
Yes.
A growing trend now is to have the mediator decide the dispute if the parties can't reach settlement.
Yes.
Some people opt to have the mediator, who's totally familiar with what everyone has said and what they both want, to turn him or herself now into an arbitrator, conduct a hearing, and decide the dispute.
Yes, that's mediation arbitration. It's become very popular, kind of grew out of California probably 20, 25 years ago. It's spread across the US and also into Canada. BC is the latest province to get on board with that, but Alberta and Ontario have been on board for a number of years.
And the United States has been doing mediation arbitration for years.
Yes.
But I think it's very important in our remaining moments to point out no one should ever sign an agreement without legal advice, correct?
Absolutely not. And even if you're going to do mediation without a lawyer, you should have a lawyer go over the original mediation agreement and confirm it's in your best interest.
Absolutely. I thank you very much for being here and explaining mediation to us. We're going to take a break. When we come back, we will go in chambers with collaborative lawyer Russell Alexander. Stay with us. Welcome back to our discussion of alternatives to family court. We're now in chambers with lawyer Russell Alexander, who is a specialist in collaborative law. Russell, thanks for joining us today.
Thank you for having me here.
Tell us, what is collaborative law?
Collaborative law is a new approach that lawyers in Ontario are taking towards resolving family disputes.
And what's different about it?
What's different is the traditional model would be lawyers would do a rights-based analysis where the client would come into the office and we would look at the guidelines or the statute and say, here's what the results would be. With collaborative practice, we take a fairly unique approach. What we do is, instead of focusing on a rights-based analysis, we ask clients, what's important to you? What are your interests? What's important to your family? Just about every client will say their children are important. Getting a fair outcome is important. And not everybody knows what that means.
Well, not everybody agrees that fair means the same thing as their ex-partner means.
That's exactly right. But what we try to do is put the clients in the driver's seat. Rather than having the lawyers dictate to the clients what the outcome would be, we find out what's important to their families. We generate options. We think of creative ways and respectful ways to resolve their disputes.
And as I understand it, collaborative lawyers agree that they're all going to work together as a team and not go to court.
That's
ever.
right. That's a fundamental principle of collaborative practice, and a lot of lawyers don't like it. Everybody enters into an agreement, and by having the lawyers say, if this agreement doesn't succeed or if we don't get a settlement, we're going to step back from the process, and the clients or the parties, the husband and the wife, have to go and retain new lawyers to start the process over again.
Does that ever happen?
It happens all the time, but not as often as you would think. Most of the lawyers who sign the agreement buy into the process.
So what kind of person then would be the ideal client? Because I have to tell you, the people I see in court are in court. They don't trust each other. They don't believe that the other person's been upfront about their assets, their income. I can't imagine that this is an ideal solution for everybody.
Well, it's not ideal for everybody. If parties or parents are prepared to treat each other with respect, provide all the information that the lawyers need to come to a proper settlement.
Which means you have to be upfront about everything you own and all of your assets, right, all of your income.
Your parenting plans, your income, your assets, so we can make an informed decision about what the outcome's going to be. So it's ideal for people who want to treat their families with respect and put their family first.
If you think that your ex is hiding money under the table, or has squandered assets or run away with money, hidden it somewhere, you're not going to want collaborative law, I take it.
Well, it takes a fair degree of trust. And what's unique about collaborative practice is we can hire a joint financial specialist to look at the assets. They can prepare a joint financial statement, a joint net family property statement. If, for example, the wife thinks the husband's hiding a bank account or an asset, he or she can go investigate that and put it on the table. And we have a very open discussion about it.
So it sounds like this is actually less expensive than the regular way that we do family law, because you could do things jointly.
In many ways, it's less expensive, not just financially, but emotionally. And let me explain why. If we go to court, it's sort of a default position. It's an adversarial position. People dig in the trenches, and they start throwing mud at each other.
Absolutely. They're not making peace, they're making war.
And it takes a very emotional toll on the husband and the wife and the children.
And it's expensive because each party's paying a lawyer by the hour.
Not only that, what you have to do sometimes is wait several months for your court date. You'll go to court, you may be on a docket with 30 or 40 cases. Your matter may be set for 9:30, you don't get called to 2 p.m.
And then you don't really know how the judge is going to rule.
You don't. Plus, you're paying your lawyer to sit on the bench waiting your turn.
Right.
With collaborative practice, once everybody signs the participation agreement, we can get the meeting started almost immediately, which means within the next few weeks, depending on everybody's schedule. You can have an initial meeting. You can decide if you're going to bring other experts in to help, such as a social worker or somebody to do a parenting plan, and you can get immediate results.
That's really one of the hallmarks of collaborative practice, isn't it? That you can bring in all kinds of coaches and experts to help the parents resolve whatever the issue is.
And sometimes it may not be a legal issue. Sometimes people are at different stages of the separation, so we can have a meeting with the lawyers and the parties. We can bring a social worker or another expert in, and they'll act as a neutral. So they'll help diffuse certain emotional issues which are blocking or delaying our ability to get a resolution.
See, I happen to think most of the couples I see are not having legal problems. Their problems are that they need to reinvent themselves from ex-partners to co-parents and try to find a way to communicate and cooperate with each other. None of that is really a legal issue. And I like the idea that you can bring in the expertise, the mental health expertise, to help them, counsel them through the pain.
And in the family court, we have case management, so it's moving towards that. But with collaborative practice, we don't need to wait 3 months for a case conference to get a recommendation that we need a social worker to help this family. We can do it within a few weeks. The family needs the help instantly. They don't need the help 4 or 5 months from now. We can get matters moving forward. We can try to work at a resolution for this family that's going to work for both parents and the children. And we can get experts involved almost instantly.
And it's very important for people to understand that if the negotiations break down and you have to go to court, you must get a different lawyer. You cannot use the lawyer you used.
Right. And part of the reason why is you're keeping everything confidential until we sign an agreement. If you don't sign an agreement, then you may have made compromises or settlement positions which you wouldn't have made during the court process.
What I like about it is that people seem to come out of the collaborative process much more satisfied, much more healed by it than what we see in court when people are so angry with what was said during this litigation.
Yeah, that's an interesting comment. A lot of times when I leave court, clients will say, "What just happened in there?" They don't even understand what the recommendation was.
Sometimes the judge is also trying to figure out what just happened. Thank you very much for being with us, Russell.
Thank you.
I'm Lauren McLean. Today on Q&A, our question is my Facebook page going to hurt my family case? We advise all of our family law clients to close their social media accounts. Let me tell you, no one has ever won a family case because of his or her Facebook page. For those of you going through family breakup, please don't post foolish comments and pictures on social media like Facebook. Foolhardy postings on social media become immortalized on the internet and remain there as ticking legal time bombs waiting to destroy your family law case. Don't post anything on social media sites such as Facebook that you wouldn't be comfortable having a judge see or hear during your family case, because trust me, they will. Damaging social media posts can be used to provide a court with a bird's eye view into your character that can lead to nasty results for you, like a loss of time with your children in a child custody case, a large money damages award against you for bad-mouthing your spouse or invading their privacy, and even fines against you, or worse still, jail time for uttering threats when you're angry. Don't jeopardize your family case with social media foolishness.
Thanks for watching. For extended interviews and exclusive content, please visit our website at familymatterstv.com. If you'd like to submit your legal question to our Q&A, go to advicescene.com. I'm Justice Harvey Brownstone. See you next time.